We've got this massive memo that is the basis, and it's a fraudulent basis, for spying on candidate Trump. Next up, the FBI lost in federal court against Judicial Watch. A court ordered the FBI to provide details on officials listed in an infamous memo written by the infamous Peter Strzok, the FBI counterintelligence official who was one of the chief instigators and promoters of the illicit spy operations against President Trump and his associates. And Strzok had written a memo, essentially to himself, authorizing this spy operation in the middle of the campaign. Really an unprecedented move. Of course, the Obama FBI and DOJ and Obama White House were more than happy to let it go forward and endorsed it and ratified it and helped push it along. But that being said, the memo we obtained, and it was a big deal because no one else had seen it until Judicial Watch got hold of it, thanks to litigation. It was called the electronic communication. The electronic communication is typically a document that's used to open and justify the reasons for counterintelligence information, counterintelligence operation. And again, in this case, it was titled Crossfire Hurricane. So this is the document, and we'll just post it online. We'll post it so you can see it closely. But you can see there are a lot of redactions. They don't black things out anymore, since I don't think they like the way that looks. So they just white it out. And so, for instance, this is CC'd to several people, but the names and the titles are redacted. Well, why is that? Now, the FBI has simply refused to turn that information over to Judicial Watch. And the court said, you know, in the least, you need to, and this is the ruling that he just issued, he wants a supplemental memorandum of up to 5 pages supported by either affidavit or declaration explaining the positions and seniority held by any persons whose names are redacted from the CC section of the document. Again, here's the CC section. So we want to know what other FBI officials were involved. Now, typically the justification the government gives for withholding the names of individuals is that they're really just low-level people, and you know they have a right to be able to do their job without the public bothering them. And you know, typically that would be, in my view, appropriate for someone who is an administrative assistant or just essentially a muckety-muck within the bureau. But in this case, it's clear these are more senior people whose names need to be disclosed, in my view, under law. And the court, that's why the court wants to know just how senior they are. And the court said, if you think that just even describing that publicly might actually tell people who the names are, then you need to give that information to me privately in court. So we'll see what the judge does with it. But this is the result of a significant fight that took place, that's been going on, since September of 2019, at least. I think we probably asked for it before then. So it's years, and we still, it's a 3-page document, maybe 4-page document. And we can't get basic information. They're also withholding the names of other countries that were involved in this anti-Trump spy effort that was illicit. So, you know, look, I'm glad Durham is doing some work finally after 3 years, 3 indictments. You know, that's government work for you, isn't it? Now, this trial of Hillary Clinton's former campaign lawyers going to be happening, I believe, next week. That's great. We'll see what happens. In the meantime, we need more information about who was involved, and we're not waiting on Durham. We've been in federal court fighting for this information. And a lot of what we know isn't because of John Durham, it's because of Judicial Watch. It's because of independent members of Congress like Devin Nunes. And I can tell you that a lot of what we know would never have gotten out, even with Devin Nunes' help and effort, without our filing lawsuits for the information that Nunes knew and highlighted was potentially there. Like the FISA warrants that were full of false information, to lying to the courts about in order to justify spy operations against the Trump campaign. Now, he said they were garbage, but we didn't see them, and they weren't released until Judicial Watch sued for them. And they were the first FISA warrants ever released, thanks to Judicial Watch. So in this case, we've got this massive memo that is the basis, And it's a fraudulent basis for spying on candidate Trump. In the filing that we had given to the court, we provided the court with 2 declarations by Kevin Brock, who was a former assistant director of the Directorate of Intelligence and former FBI principal deputy director at the National Counterterrorism Center. Brock testified that it is not standard procedure to have an electronic communication drafted, approved, and sent to and from a single agent, and that doing so violates FBI protocols. This is what he says. In the EC document here, the from line indicates the EC an authorization to begin an investigation as required under FBI policy is from a part of the FBI's counterintelligence division. The contact listed is Peter Strzok. The EC was drafted by Peter Strzok. The EC was approved by Peter Strzok. On the face of the document produced, it appears that the EC was initiated a criminal FARA investigation, Foreign Agents Registration Act investigation, of unidentified members of the Trump presidential campaign, was created by Peter Strzok and approved by Peter Strzok and sent from Peter Strzok to Peter Strzok. This is not the usual procedure. I always think of that song, I'm going to sit right down and write myself a letter and pretend that it came from you. I mean, this is what was going on in our FBI. FBI policy prohibits an agent from initiating and approving his or her own case. Such action violates FBI oversight protocols put in place to protect the American people from an FBI agent acting unilaterally. In fact, the EC, the electronic communication, does not identify any individual by name as a target of the investigation. It does not articulate any factors that address the elements as required by routine FBI policy and procedure and the Attorney General guidelines, and therefore does not contain sufficient justification for initiating an investigation into U.S. persons. Based on my experience, no reasonable and experienced FBI counterintelligence squad supervisor in the field would have approved the electronic communication issue here as released, which opened the Crossfire Hurricane investigation. The unredacted information released in the EC document here offers no legitimate predication justifying the investigation of U.S. persons involved in a presidential campaign or subsequent FISA intercept of a U.S. person. Outrageous, isn't it? And they don't want us to know. So here we have the Biden administration acting to cover up information about corruption from the Obama administration. Corruption which actually continued under the Trump Justice Department and FBI. And now Biden, who is the most corrupt president to be in office since he was vice president, his agencies are protecting and defending the indefensible and trying to hide from you, the American people, the details of the spy operation against President Trump. And Judicial Watch, slowly but surely, is chipping away. I like to say we smash through the stone walls, but in this case, we're chipping away at the stone wall to get more truth and more accountability. And hopefully the court gives us that once the FBI is forced to disclose more information about who Peter Strzok was talking to about spying on Trump based on trumped up information. Really incredible stuff. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.